can give me...
Within 40 minutes, Wexner's name was added back.
Within 40 minutes of me catching you red-handed.
There was one redaction out
Where
of
he's
over
listed as a co-conspirator.
4,700, and we invited you in.
Gentlemen,
This guy has Trump derangement syndrome.
The hearing room inside the House Judiciary Committee was packed that morning, filled with lawmakers, reporters, aides, and observers who had gathered expecting what seemed like another routine day of congressional questioning. The atmosphere carried the usual tension that accompanies high-profile political hearings, but nothing suggested that the room was about to fall into complete silence. At the witness table sat Attorney General Pam Bondi beneath the bright overhead lights, appearing confident and composed. She was surrounded by her legal team, with 3 attorneys seated beside her and several aides positioned just behind her. Years of courtroom experience and political battles had made her no stranger to scrutiny, and to most people watching, it looked like she was prepared for whatever questions the committee might throw her way. For several minutes, the hearing proceeded normally, with members delivering statements and asking predictable questions. But everything changed the moment Congressman Thomas Massie opened a thick red folder resting on the desk in front of him. The movement seemed small at first, but inside that folder were documents that no one in the room had expected to see. Without raising his voice or making a dramatic announcement, Massie slowly pulled out the first sheet of paper and held it up for the cameras and the committee members to see. The room grew noticeably quieter as he calmly began to speak. The document, he explained, was a wire transfer authorization dated February 8th, originating from the Department of Justice's Financial Management Division. According to the record, $847,000 had been transferred from a DOJ account to another account ending in the numbers 7473. That receiving account, Massie continued, was registered to a company called Executive Branch Consulting Services, LLC. At first glance, the name sounded ordinary enough, but the details surrounding it were anything but normal. The company had no employees listed, no registered office address, and no clear operational history. It appeared to exist only on paper. A faint murmur began moving through the hearing room as reporters leaned forward and committee members glanced at one another. Massie then pointed to a line in the document that described the purpose of the transfer. The authorization stated that the payment was made for a legal settlement tied to an executive privilege claim involving a classified matter. Lowering the document slightly, Massie looked directly toward the witness table and asked a single question that immediately froze the room. "Madam Attorney General, can you explain this transfer?" For a moment, it seemed as if Bondi was about to respond. She leaned slightly toward the microphone, her posture shifting as though preparing to answer. But then she stopped. Seconds passed. The silence became heavier with each passing moment as every person in the room waited for her response. Instead of filling the silence, Massie continued. He explained that the wire transfer was only the beginning of what investigators had uncovered. Just 3 hours after the money was sent, the Department of Justice press office issued a brief statement describing the transaction as part of a confidential legal matter that could not be discussed publicly. Massie paused again and scanned the room. His voice remained calm but carried an unmistakable edge. "In a democracy," he said, "how does it work when taxpayer money is moved in secret and Congress is told it cannot ask questions?" Bondi finally responded, but her words were careful and controlled. She stated that she categorically rejected any suggestion of improper activity within the Department of Justice. Massie nodded slightly, acknowledging the statement, but not backing down. "You can reject it," he replied, "but the document still exists." Reaching back into the red folder, he produced another paper, an internal Department of Justice memo dated February 11th, just 3 days after the wire transfer. The memo had been circulated through the Office of Legal Counsel and sent to multiple divisions inside the department. The subject line read, "Executive Branch Protection Protocols." Massie began reading directly from the document, quoting the portion that declared all materials related to Settlement Agreement EP0225 to be immediately designated as attorney-client privileged and exempt from public information requests. He stopped reading and looked back toward the witness table. Attorney-client privilege, he explained slowly, normally protects communications between a lawyer and their client. The question, he said, therefore becomes obvious. Who exactly was the client in this situation? Was it the Department of Justice itself or someone else entirely? The room's tension continued to build as journalists typed rapidly on laptops and cameras shifted closer to capture every expression on the faces of those involved. Bondi's expression remained controlled, though the attorneys seated beside her began whispering urgently and exchanging notes. Massey continued, revealing that 6 days after the transfer, another unusual development occurred. He held up a printed email from a Treasury Department analyst who had reviewed the financial transaction. According to the message, the receiving entity's lack of employees, business activity, or physical address met the criteria for a suspicious activity report, a formal financial alert typically required under federal regulations. But the analyst's supervisor had replied with a short instruction: do not file the report. The matter, the supervisor wrote, was classified and had been designated an executive branch decision. Massey set the email down carefully and addressed the committee again. Someone, he said, had intervened to stop a legally required financial alert. That meant an investigation that should have been triggered was instead halted before it began. Turning back toward Bondi, he added that the American people deserved to know who had made that decision. The room had become so quiet that even the sound of papers shifting echoed across the chamber. Yet the documents in Massey's folder suggested the situation was even more complicated than anyone initially realized. The account that had received the $847,000 did not remain idle after the first payment. Over the following 2 weeks, additional deposits began appearing. Massey held up another document obtained through a federal court order showing the complete transaction history of the account. Slowly and deliberately, he began reading the entries. On February 8th, the account received the original $847,000 from the Department of Justice. 4 days later, on February 12th, another deposit appeared, $293,000 from an organization called the National Security Litigation Fund. 3 days after that, on February 15th, a much larger deposit came in, $1.2 million from something identified as the Presidential Legal Defense Trust. By this point, the combined deposits had totaled $2.3 million. But what happened next drew even stronger reactions from those in the room. On February 24th, according to the records, every dollar in that account was transferred out. The funds were split into 3 separate international transfers. One went to a bank in Switzerland, another was sent to a financial institution in Singapore, the third moved to an account located in the British Virgin Islands. Each destination account was registered under trustees whose identities were shielded by international banking secrecy laws, making it difficult to determine who ultimately controlled the money. Massey then pointed to a handwritten notation at the bottom of the transfer authorization page. The note described the payment as a settlement related to what was labeled the J matter. Pausing briefly, Massey read the full phrase out loud: settlement of claims connected to Jeffrey Epstein. The moment those words were spoken, the chamber erupted. Members of the public gallery began shouting, reporters jumped to their feet, and camera operators rushed forward to capture every chaos. The committee chairman repeatedly struck the gavel, demanding order, as the room struggled to calm down. Through it all, Bondi remained seated at the witness table, silent, while her attorneys leaned in close and whispered urgently. Once the room quieted slightly, Massey approached the microphone again and asked a direct question. Did the Attorney General recognize the transaction that had just been described? There was no response. He asked again whether she knew who ultimately received the $2.3 million tied to settlement claims involving Epstein. Again, no answer came. Finally, Massey removed the last document from the red folder. This document, he explained, was perhaps the most troubling of all. It was an internal Department of Justice list created in 2023 and updated again in 2025. The title printed across the top read, "Existing Individuals Excluded from Epstein-Related Investigative Activities." According to the document, the list contained 47 names. Next to each name was a classification code explaining why that person had been shielded from investigation. Massey read the categories aloud. Code A represented political sensitivity and included 12 names. Code B referred to diplomatic relations and included 8 names. Code C cited national security concerns and listed 15 more. Then he paused before reading the final category. Code D, he said slowly, represented executive branch protection and included 12 additional names. In other words, the document suggested that a group of individuals connected to the Epstein case had been officially designated as protected from investigation by executive authority. Leaning toward the microphone, Massey asked one final question that echoed through the room. Is this truly about national security, or was it simply a cover-up? By that point, Bondi's legal team was scrambling to organize a response, passing notes and whispering urgently. Yet the Attorney General herself remained silent. Massey glanced down at the clock in front of him and quietly noted that 92 seconds had passed since his first question about the transfer. 92 seconds during which an explanation could have been offered, a denial could have been issued, or some